Mr. Andrei Iancu. He's a co-chair of the Council of Innovation Promotion, a partner at the law firm Sullivan and Cromwell. Between 18 and 21, he served as director of the U.S. Patent and Trademark Office. Mr. Iancu earned his JD, his MS in mechanical engineering, and a BS in aerospace engineering from UCLA. Mr. John Lee is Senior Director and Head of Intellectual Property Policy at the Computer and Communications Industry Association. He previously served as Chief Counsel for Intellectual Property on the House Judiciary Committee. Before that, he worked as lead administrative patent judge on the Patent Trial and Appeal Board at the U.S. Patent and Trademark Office. Mr. Lee received his law degree, BAS in bioengineering and BA in biology and neuroscience from University of Pennsylvania. Dr. Deborah Leonard fills, no, I'm sorry. I skipped one here. Sue Peshin serves as President CEO of the Alliance for Aging Research. She also serves on many boards, including the Association of Black Cardiologists, National Health Council, Voices of Alzheimer's, and others. Ms. Peshin received her master's degree in health policy, Johns Hopkins Bloomberg School of Public Health, and her bachelor's degree in sociology, Brandeis University. Dr. Deborah Leonard fills out the panel. She currently professor of pathology and laboratory medicine emerita at the Robert Larner MD's College of Medicine. That's at the University of Vermont. She serves as chair of the Department of Pathology and Laboratory Medicine until last year. Dr. Leonard earned her MD degree and her PhD in biochemistry from New York University and her bachelor's degree in biology from Smith's College. Now, before you testify, we have a practice here of swearing people, so would you please stand? Do you swear or affirm that the testimony you're about to give before this committee will be the truth, the whole truth, and nothing but the truth? So help you God. You've all responded in the positive, and so we'll start out with Mr. Iancu. Please proceed.
Thank you, and Chairman Grassley, Ranking Member Durbin, and members of the committee, thank you for the opportunity to testify today. Before I begin, I want to say that I am heartbroken about Senator Gramm's passing. I was very much looking forward to seeing him on the dais today. He chaired this committee when I was PTO director, and I have only fond memories of our meetings. He was gracious, smart, witty, and he loved this country. He was a statesman in the best sense of the word. He fought hard for his beliefs, and he reached across the aisle when it served America's interests. May others follow his lead, and may his memory be a blessing. My message for this hearing is simple. Congress has not meaningfully updated the basic statutory categories defining what kinds of innovations and technology may be patented since 1793. Technology has changed a bit since then. Indeed, it has changed beyond recognition. The statute has not. What belongs in the patent system is a major policy question. The Constitution assigns that question to Congress. I urge Congress to answer it. And because Congress has not done so, courts have filled the void. And over the past 15 years, courts have expanded judicial exceptions that Congress never wrote and that lower court judges say they cannot administer consistently or fairly. The consequences are real. The result is uncertainty in the technologies that will define the century: computing, medical diagnostics, biotechnology, artificial intelligence, and so much more. For example, courts have rejected tests that diagnose serious diseases as laws of nature. They have rejected improved digital camera technology as an abstract idea. And they have treated the collection, analysis, and presentation of information as categorically suspect and likely not in the patent system. The resulting uncertainty discourages the resource-intensive research America needs to confront its greatest challenges, from detecting and treating thousands of diseases that remain without effective therapies to equipping our military with the most advanced computer-assisted technologies. Meanwhile, Europe, China, Japan, and South Korea, the biggest other IP jurisdictions, protect inventions that American courts turn away. That is a self-inflicted competitive disadvantage in precisely the fields in which the United States is competing for technological leadership at this time. The burden falls especially hard on small innovators. Large companies can rely on scale, secrecy, and litigation budgets. For startups and other small businesses, patents may be their principal asset, the foundation for attracting capital, hiring employees, and bringing a product to market. Reliable patent rights also encourage inventors to disclose their breakthroughs rather than keep them secret, allowing others to learn from and build upon them, and they help attract manufacturing and investment to the United States. PERA would restore clarity. It preserves the broad technology-neutral framework that has served the country since 1793, while replacing unpredictable judicial exceptions with a defined list of matter that Congress decides to exclude from the patent system. One clarification is essential, though. The patent laws impose several distinct requirements. Section 101 asks only a threshold question: is this the kind of technology the patent system may protect? Other provisions determine whether the invention is new, non-obvious, and adequately disclosed. Eligibility is not patentability. Passing through the gate does not guarantee a patent. PERA is only about eligibility and leaves the patentability standards unchanged. The American patent system is a powerful engine of investment and growth.